Myself Vasundhara Garg, Assistant Professor in Babu Banarsi Das University. My today's topic is Hierarchy of Courts. So here in India, as you know, there are three branches of government, that are legislature, executive and judiciary. India's constitution states the division of power and system of the check and balance. The judiciary plays a critical role in ensuring that the legislature and the executive do not exceed their constitutional boundaries and prevents them from the arbitrary exercise of powers. The Constitution of India ensures that the judiciary remains independent of the influence of the legislature and executive. So, history of judicial system in India. In ancient time, the lowest court was the family court, starting from the family arbitrator, and the judges at the highest pedestal was the king. One of the primary duties of the sovereign was the dispensation of justice, and in this process the king was aided by his counselor and ministers. As the civilization advanced and the duties of the king were delegated to the judges who had knowledge of Vedas, justice was administered on the basis of dharma, or a structure of rules specifying the responsibilities that an individual must fulfill in his life. Customs served as the sources of law. This system continued till the Mughal period. During the Mughal period, the office of Qazi was responsible for the dispensation of justice. Every provincial capital and every large town had a Qazi. The Qazi held a trial in the presence of the parties, who were expected to write their legal documents very carefully. The king was the highest court of the appeal. This system of justice was replaced by the British. So when the Britishers came to India, they introduced the common law system in India and established the Sadar Diwani Adalat. They were later followed by the establishment of high courts. The first high court was established at Calcutta in 1862. The high courts were also established in Madras and Bombay. Subsequently, the federal court was established by Government of India Act 1935, which had a wider jurisdiction than the high courts. Thus, the present judicial system of India is based largely on the common law system. Now come to the functions of the Indian judiciary. Following are the few functions of Indian judiciary. For example, upholding and interpreting the constitution, resolving interstate disputes, protection of fundamental rights. Our main topic is hierarchy of courts. The Indian judiciary is divided into several levels in order to decentralize and address matters at the grassroots levels. The basic structure is as follows. Our apex court is Supreme Court. It is established or constituted on 28 January 1950. Article 124 to Article 147 of Indian Constitution lay down the authority of the Supreme Court. The next one is High Court. High Court are the highest judicial body at the state level. Article 214 lays down the authority of High Court. There are 25 High Courts in India. These High Courts exercise civil or criminal jurisdiction only if the subordinate courts in the state are not competent to try the matters. High Court may even take appeals from the lower courts. Now come to the district court. After High Court, there are district courts which are established by the state government of India for every district. These district courts are generally divided into civil courts or criminal courts. Now, next one is Lok Adalat, or we can call it village courts. These are subordinate courts at the village level which are provide a system of alternate dispute resolution in villages. Next one is tribunals. The Constitution provides the government with the power to set up special tribunals for matters such as tax cases, land cases, consumer cases, etc. What do you mean by civil courts? Civil courts provide remedies for civil wrongs committed by individual against other individual and entities. Civil matters range from property dispute to breaches of contract to divorce cases. Civil courts follows the principle of ubi jus ibi remedium. That means for every wrong the law provides remedy. The CPC 1908 governs the procedure to be followed by the civil courts. As a matter of fact, every suit must be instituted before the court of lowest jurisdiction as stated under section 15 of CPC. Now come to the hierarchy of district court. The first one is the district judge. The district judge headed the district court. Then come to the additional district judge. And lastly, the Munsif Court. Lastly, come to the criminal codes. Power of various criminal codes is mentioned under Code of Criminal Procedure, that is CRPC. According to Section 26 of CRPC, any offence mentioned under Indian Penal Code may be tried by the High Court, Session Court, or any other court as specified in the first schedule of the CRPC.